Hi, Advocate Prakhar. Hi, Advocate Siddharth.
Hi, Rishwin.
Hi,
Hi,
sir.
Rishwan.
Hello. Uh, Sir, very recently we heard that the Gujarat High Court, in one of its judgments, has held that the Indian parties can now choose foreign seats for arbitration and can even enforce the same arbitral award in India. So, could you please help us understand how this exactly works?
Sure, Rishwin. This is a recent case titled G Power Conversion India versus PASL Wind Solutions. So there were two companies, G Power Conversion, which has its registered office at Chennai, and the second one, PASL, had its registered office at Ahmedabad. The case in question pertained to certain converters being provided by the petitioner to the respondent, namely 20 950 kilowatt. Two were to be supplied initially and 18 were to be ordered later. Two converters of 1250 kilowatt and two converters of 1800 kilowatt. Six were supplied initially, and the dispute pertained regarding to the purchase order. And the case of the petitioner was that it had already provided a large number of free services, repeatedly pertaining to converters. The warranty of the converters had expired, whereas according to the respondent, the warranty on the converters was continued. In order to resolve the dispute, the parties entered into a settlement agreement, which was dated 23 of December 2014. Clause 5.2 of the settlement agreement read as follows, and I read, G will extend 14 months warranty attributable to converters for above mentioned converter, namely 1800 kilowatt, from the date of recommissioning of panel after replacement of delta modules. The warranty would be 20 months from the date of supply or 14 months from the date of commissioning, whichever is earlier. As per the settlement agreement, PSL handed over two checks amounting to 26 lakhs. This is 2 crore 60 lakhs, by the way, and INR 7 lakh rupees. And both the parties agreed that any further dispute would be resolved in an amicable way before it can be referred to arbitration. Clause 6.2 contains the arbitration clause, and I read it. In case no settlement can be reached through negotiations, all disputes, controversies, or differences shall be referred to and finally resolved by arbitration in Zurich in the English language in accordance with the rules of conciliation and arbitration of the International Chamber of Commerce, which rules are deemed to be incorporated by reference into this clause. The arbitration award shall be final and binding on both the parties. Since the disputes could not be resolved, on 3rd of July 2017, the respondent issued a request for arbitration, and on August 2018, the parties agreed to resolve resolution of disputes by the sole arbitrator. Mr. Ian Makin, under the ICC rules, was appointed as the sole arbitrator, who was located at Geneva, Switzerland. Pursuant to the proceedings indicated that the petitioner had filed a preliminary application challenging the jurisdiction of the arbitrator on the ground that since the two parties were Indian parties, they cannot have a foreign seat of arbitration. The said application was rejected, and the tribunal held that the arbitration clause in settlement agreement is valid and will proceed to apply the Swiss Act because the seat of arbitration is Zurich. Now further, the petitioner suggested that Mumbai should be a venue, which was again rejected. The arbitrator thereafter passed the arbitral award after conclusion of final arguments on 18th of April 2019 and granted the petitioner 2 crore 59 lakh 76,330 rupees and USD 40,000 in legal costs and expenses with accumulated interest in accordance with the Indian Interest Act 1978. The matter again came to enforcement, and the petition was filed for, and this petition was filed for enforcement of the above award. Gujarat High Court formulated three questions while dealing with the issue, and I will initiate the three questions. One, is the award in question a foreign award? Two, is the foreign award in question enforceable in India? Three, whether an application under Section 9 in the context of the agreement in question maintainable before this court. I will deal with these questions one by one. Is the award in question a foreign award? In order to deal with the question number one, the court considered sections 2 subsection 1 clause E, section 2 subsection 2 clause 7, section 28, section 31 of part 1 and pertinently section 44 of the part 2 of the Act, and held that Particularly for determining whether an award is a foreign award, we must turn towards Section 44, which defines foreign award. The court also quoted the position in Balco judgment. The court said that after reading Section 44, the following ingredients of a foreign award can be identified. And I quote, it must be an arbitral award. 2. The award must be deducted upon an adjudication of a dispute between the parties. 3. Such dispute must be owing to and or arise from a legal relationship. 3. Such legal relationship may or may not be contractual, however, must born out to be commercial in nature, must be pursuant to an agreement in writing to which the New York Convention applies, must be made in territory recognized by the central government as a territory to which the New York Convention applies. It was argued by the respondent that since it involves Indian parties and lacks foreign element, therefore it must be declared as a domestic award. But the court said that considerations of such nature cannot be sole reason for determining and declaring an award as a domestic award. The court based its conclusion on following foundations. A. The definition as available under the Section 44 can be held to be the sole repository for determining an award to be a foreign award. Section 44 of the Act lays down exhaustively the essential ingredients for determination of an award to be a foreign award. Neither inferences nor intentions to presume any other ingredients than those provided under Section 44 should be regarded as permissible for determining an award as a foreign award. The court further concluded that the nationality of the parties has no relevance for considering the applicability of Part 2 of the Act of 1996. Applicability of Part 2 is determined solely based on what is seat of arbitration, whether it is a country which is a signatory to the New York Convention. If this requirement is fulfilled, Part 2 will apply. Court further went on to quote from Balco and BGS Soma versus NHEC. On various hearings and communication between the parties, it was constantly emphasized that the place of arbitration is Mumbai, but in fact the seat of arbitration is and remains Zurich, Switzerland, and hence the award is a foreign award. The court hence ruled that this award is a foreign award. Now we come to question number 2, which was framed by the court. Is the foreign award in question enforceable in India? In order to answer the question, the court took recourse of the judgment of Supreme Court in Furist Bay Lawson Limited versus Jindal Exports, where 2 stages of enforcement of a foreign award are initiated. Stage 1, where the court would make an inquiry into enforceability of the award. Stage 2, where the court holds that the award is enforceable. For the enforceability at the stage 1, the High Court examined Section 47, which talks about evidence. The party applying for the enforcement of an award shall at the time of application produce before the court certain things, like original award or a copy thereof, duly authenticated in the manner required by the law of the country, the original agreement for arbitration or a duly certified copy thereof. Such evidence as may be necessary to prove that the award is a foreign award. 2. If an award or agreement to be produced under subsection 1 is in a foreign language, the party seeking to enforce the award shall produce a translation into English certified as corrected by a diplomatic or consular agent of the country to which that party belongs, or certified as corrected in such other manner as may be sufficiently according to the law in force in India. The High Court said that since the subject matter of the present proceedings is the assets of the respondent against which enforcement is sought, hence this court has the jurisdiction to hear the present petitions, as the assets of the respondent are located in the court's jurisdiction, and some of these assets have also been identified at paragraph 55 of the enforcement petition, which comes later. The court again cited Balco judgment, which reads, Section 47, which is Part 2 of the Arbitration Act 1996, dealing with enforcement of certain foreign awards, has defined the term court as a court having jurisdiction over the subject matter of the award. This is a clear reference to a court within whose jurisdiction the asset person is located, against whom the enforcement of the international award is sought. For deciding whether the award is enforceable, the court considered Section 48 of the Act and cited the judgment in case of Vinay Karya versus Perismian Savi E Systemis SRL of Supreme Court, which explained the narrow scope of Section 48. Coming to the next point, the Apex Court also said that even if some of the grounds under Section 48 of the Act are present, the court is at its discretion and may enforce the foreign award. It further held that an allegation that the tribunal did not consider critical evidence is not a ground available under Section 48, and any scrutiny of the tribunal's analysis of evidence was selective and perverse is also not available under this section. The respondent resisted the enforcement of the award and contended that since the arbitration involves two Indian parties who have acceded to designating their seat of arbitration outside India, such agreement would not be considered with inconsistent with Section 28 of the Indian Contract Act and therefore hit by Section 23 of the Act, rendering the contract illegal and against the policy of India. The Gujarat High Court referred to the judgment of the Apex Court in Renu Sagar Power Company Limited and Glencore International AG versus Hindustan Zinc Limited, wherein it was held that in these judgments that there has to be a narrow construction of the public policy defense. Contravention of law alone will not attract bar of public policy, and something more than contravention of law is required. It was also held that the scope and ambit of expression public policy of India must necessarily be construed narrowly to mean the fundamental policy of India, and as clarified by the explanation of Section 48, subsection 2, conflict with the public policy must involve the element of fraud or corruption. The Hon'ble High Court further stated that it is well settled principle that by agreement the parties cannot confer jurisdiction on a court when it doesn't exist. But this principle does not apply when parties agree to submit to exclusive jurisdiction of a foreign court. The court thus clarified that parties to a contract may agree to have their disputes resolved by a foreign court, termed as a neutral court or a court of choice, creating exclusive or non-exclusive jurisdiction in it. Together with a combined reading of the above position of law, the explanation in Section 28, it is further observed that the Act 1996 does not per se prohibit two Indian parties specifically from designating a foreign court and vesting in it exclusive jurisdiction to supervise its arbitration proceedings, and therefore the parties designating the seat of arbitration as Zurich does not infringe any Indian law or is forbidden by Indian law. So we have dealt till now with two questions that were framed by Gujarat High Court. Now we will come to the third and the last question that was framed by Gujarat High Court, that is whether an application under Section 9 in the context of the agreement in question is maintainable before this court. The petitioner has filed a petition under Section 9 of the Act along with the enforcement petition in order to seek an injunction from disposal of assets of the respondent to secure the foreign award, and so that is not left as a paper decree upon enforcement. The petitioner cited the case of Tramco DMC versus Nagarjuna Fertilizers and Chemicals Limited, which quotes, a party in enforcing a foreign award and seeking recourse to Section 9 of the Act cannot be left without an effective remedy. In a situation akin to the facts in the present case, this interpretation, in my opinion, suffices and fulfills the legislative intent in making Section 9 inter alia available in enforcement of foreign awards. Court further said, and the petitioner contended, the petitioner submitted that the 246th Law Commission report recognizes this and has accordingly recommended that Section 9 should apply even to arbitration seated outside India. Criteria for applicability of Section 9 to a foreign award identified by the Law Commission is that the seat of arbitration should be outside India and nationality of the parties has no role to play in it. It also noted that a party holding a foreign award should be protected during the enforcement of a foreign award. A very valid point. The petitioner further cites a recent judgment passed on August 19th, 2020 of Evitel Post Studios Limited versus HSBC. The court dismissed an SLP against a Section 9 order granted by Bombay High Court protecting the foreign award holder. The court directed that an amount of $60 million be deposited in the court pursuant to Section 9 petition pending the enforcement of the foreign award. This is just to protect the interest of a decree holder so that there is a lien on the amount that is decreed. The respondent argued that the proviso to Section 2, subsection 2 applies only to the international commercial arbitration outside India, which as per the definition of the international commercial arbitration, Section 2, subclause 1, Section 2, subsection 1, clause F required at least one foreign party, which does not exist in the present case. The Gujarat High Court, while appreciating the submissions of both the sides, hold that the plain language of proviso to Section 2, subsection 2 reads to imply that the provisions of Section 9 and Section 27 of Section 37 shall also apply to international commercial arbitration, even if the place of arbitration is outside India and an arbitral award made or to be made in such place is enforceable and recognized under the provision of Part 2 of this Act. While interpreting the provision ejusdem generis, the court accepts the submission of respondent that the proviso of Section 2, subsection 2 applies only to international commercial arbitration. It further holds that it is settled principle of law that the court cannot read anything into a statutory provision which is plain and unambiguous. The statutes should be construed not as theorems of Euclid, reliance upon Tramco versus Avitel Post, to the extent that it intends to read more than what the language of the proviso of Section 2, subsection 2, therefore implies it to be an insignificant, and hence application under Section 9 is not maintainable. Thus, in this court, we can see that the court actually talked about three important questions, two of which were held in favor of the petitioner and one in favor of the respondent. Namely, the award in question is a foreign award. The court held as yes, it's a foreign award. Is the foreign award in question enforceable in India? Court held yes, it is enforceable in India. Whether an application under Section 9 in the context of the agreement in question is maintainable before the court held no, Section 9 applicable in the context of the agreement in question is not maintainable under this court. With this, I will sum up my submissions and my reading of the important judgment of Gujarat High Court in G Power Conversion India versus PASL Wind Solutions. Thank you.
Thank you so very much, sir. This has been extremely enriching. I'm sure this will go a long way in helping our audience understand exactly what the judgment talks about.